Thanks for downloading this episode of On the Record Online with Eric Schwartzman, the podcast about how technology is changing the world of communications. To subscribe to the podcast or share feedback, visit us online at ontherecordpodcast.com, on Twitter @ontherecord, or send email to ontherecordpodcast@gmail.com.
We're talking to Doug Bonney. He is the Chief Counsel and Legal Director for the American Civil Liberties Union in Kansas. And we're talking to him about the Kansas Board of Regents' decision to update their social media policy, which is getting a lot of discussion online. What's the issue? What are people talking about, Doug?
Well, the issue is, first, whether this was even a necessary policy, whether there was any real legitimate reason to implement a social media policy. And we believe the answer to that is no. And then the current talk is, how is this affecting discourse among faculty and staff people at Regents institutions? And I'm hearing that it is causing people to abandon their social media talk on platforms like Facebook.
So when you say, we believe there's no need for social media policy, is that basically an ACLU thing? I mean, does ACLU basically say, look, there should be no social media policies at employers?
Well, the problem with social media policies, and we're talking about public entities, which are subject to the First Amendment, the problem with them is that they are extremely hard to write in a way that has any meaning. Either they are over the top in censoring people's protected speech, or they're kind of vague and overbroad, mindless pablum that poses a risk of chilling people's legitimate free speech interests because they don't know what the policy means. And frankly, that's the problem with the Board of Regents policy.
Now, in the private sector, people are concerned about the NLRB, the rights of federal workers to have concerted conversations on social media about wages, hours, and working conditions being chilled by a private employer's social media policy. Would that same concern apply at a public organization like a university?
Restate your question, because you got me a little bit lost in. I mean, I'm familiar with the NLRB rulemaking, but
right. Well, obviously, the National Labor Relations Act protects workers' rights to organize and bargain collectively. You can't be fired for that. It's a federal right. And there's been a number of instances where employers have terminated employers for having confidential conversations on social media, which could be about wages, hours, or working conditions. And if those conversations were in fact concerted to organize co-workers to try to improve their working conditions, it's protected. And so that's been a common issue that's talked about when private employers talk about creating lawful social media policies. That's like one of the biggest challenges. And what I wonder is, would an employee of a university be protected by the National Labor Relations Act as well, or are public entities somehow different?
Yeah, so the National Labor Relations Act only applies to private sector employers, and only private sector employers outside of the railway and airline industries, because railway and airline employees have their own labor law. That's called the Railway Labor Act. I spent nearly 25 years as a union side labor lawyer, so I know something about this area. Mm-hmm. And so the NLRA only applies to private sector employers, so it has no application to employees of public universities or community colleges, and that's what the Board of Regents policy talks about. The employees, though, in Kansas of public universities and community colleges, they have a bargaining law that is in some ways similar, in many ways dissimilar to the NLRA, though. But the underlying, this policy, we're not so concerned particularly about organizing rights and that kind of speech, although certainly these employees would have a First Amendment right to talk about working conditions. We're really worried about people talking about things that are important public issues, and then feeling at risk because they've chosen to speak about those issues on social media, which this policy defines pretty specifically to apply to blogs, wikis, and social networking sites. And so the danger is that people will be chilled in their speaking out on issues of public concern by this kind of vague and overbroad policy.
Clarify one more issue for us. So my understanding, albeit limited, of First Amendment rights is that they apply mostly to the government controlling what people say. And that in the private sector, you do actually, if you're an employee of a private commercial organization, you do actually sacrifice some freedoms when you're in the workplace. How does, when it comes to public entities, are your free speech rights even stronger because you're essentially working for the government? So would you have even greater free speech rights than you would as an employee of a private organization?
Well, the First Amendment applies to governments, not to private entities. And so you don't have more rights as a public employee than you would as a non-public employee citizen. The non-public employee citizen has more First Amendment rights than the public employee does. And that's because the public employer as employer has certain rights to impose very limited regulations on the speech of its employees. A citizen, for instance, a citizen can go out and say pretty much anything he or she wants, and the government cannot criminalize that speech. The government as employer might be able to discipline an employee for saying something that, divulging confidential information, for instance. That's pretty clear limit. It's speech, but it's, the right of the public employee to engage in it is limited, so they couldn't do that. The other issue you're talking about private employers infringing on their employees' ability to speak out on certain things. That's true, but it really doesn't have anything to do with the First Amendment. It's that private employers sometimes impose rules. It's fairly rare, frankly, that this happens. It's, an overt rule saying you can't talk about X or Y. In fact, we did a case a few years ago using a Missouri political campaign finance statute that we sued a company that had basically told its employees, you can't speak out in favor of non-Republicans. So, that violated a statute in Missouri that that restricts private employers from imposing restrictions on their employees' political speech.
I want to read you a passage from the Board of Regents Kansas Board of Regents social media policy. It's a passage that I'm reading a lot of people are talking about in the press, and I don't understand something. So it says 3. The United States Supreme Court has held that public employers generally have authority to discipline their employees for speech in a number of circumstances, including but not limited to speech that. And then number 3 says, when made pursuant to the employer's official duties, comma, is contrary to the best interests of the employer. And so a lot of people are saying, well, that's overly vague. But then later on, 2 paragraphs down, it does say, in determining whether an employee's communication is actionable under subparagraph 4, the interest of the employer in promoting the efficiency of the public services it performs through its employees must be balanced against the employee's right as a citizen to speak on matters of public concern, which, to me seems pretty reasonable. I mean, that doesn't seem too vague. Does that seem vague to you? Where's the danger in that?
Okay, this part of the policy, the 2 provisions that you quoted from, 3II and the final part of 3IV, actually refer to specific Supreme Court cases on public employee free speech. Little II, where it talks about speech made pursuant to the employee's official duties, that comes from a case called Ceballos versus Garcetti, and there the public employee who was a assistant prosecutor in L.A., spoke on something as part of his job, and the Supreme Court held essentially, well, you don't have First Amendment rights that protect you when your speech is part of your job. I disagree with that holding, but that's what the holding was. The other part you talked about, the balancing test, that comes pretty much straight out of a 1960s case, really one of the first public employee free speech cases, a case called Pickering versus Board of Education. And so the Supreme Court does apply a balancing test in these cases. The vagueness of the policy actually pops up in other places where it talks about improper use of social media, but it never really defines improper use. So there's no real way for employees to figure out, oh, what's this mean? And so it's going to mean that people err on the side of an amendment to caution, and really that's not what the First Amendment's about. The First Amendment is about making sure there's a wide open and robust debate on public issues. And where governments impose this kind of vague and overbroad policy, it really crimps the style of people to engage in that wide open debate. And so it hurts the democracy as a whole.
Given your sort of knowledge of the history of these types of policies and of free speech and civil liberties, does this strike you as bizarre that this policy actually gets written and then it gets approved by the district attorney? I mean, do you see this type of thing happening in other states frequently, or is this sort of an outlier?
Well, this one came about for a very specific reason. A journalism professor at the University of Kansas, right after the Navy Yard shooting last September, posted a, kind of inflammatorily worded tweet that
I have it.
criticized the NRA.
Let me just read it for people who haven't seen it. It says, #Navy Yard shooting. The blood is on the hands of the #NRA, period. Next time, comma, let it be capital your sons and daughters, period. Shame on you, period. May God damn you, period.
Right. And so that led to threats by various legislators to cut off funding to the University of Kansas and, probably, frankly, broader than that. And there were calls for this professor's head. The thing is that I don't think anybody that has seriously looked at this has said that that professor's speech, whether it was well advised or not, that's a different issue. But everybody agrees that that tweet was protected by the First Amendment and that that professor could not have been legitimately fired for making that tweet. But that tweet is what caused the Board of Regents to adopt this policy. And really, it's kind of your typical overreaction to one incident and adopting a policy that there wasn't a real clear need for, and that's where we are now.
How could the argument be made that this professor is in some way a representative of the university for which he works? Walk us through that.
Well, he sent that tweet on his own account from his home, away from the university, not using any university assets, property, or time. He wasn't being paid by the university at the time. And so I don't think there's any way you can make it that was somehow university speech.
So just to wrap this up for us, so you're saying, the ACLU basically says, look, you can't do social media policy. It limits people's civil liberties. But at the same time, there's this host of rules and regs out there that impact how you can and cannot lawfully use social media. And while you may have freedom of speech, there are certainly consequences to free speech, defamation, harassment, discrimination, invasion of privacy, all these different things. So how should an employer, in this case a public employer, best protect itself from getting in trouble for the actions of its employees? Is it policy? Is it training? Is it both? What's the right way to go?
Well, both of those things. Appropriate policies that are limited to conduct at the workplace. That's where the universities have the authority to regulate their employees' conduct. And so, there can be First Amendment issues to these policies, but any prudent university will have a sexual harassment policy, for instance. And so a well-crafted sexual harassment policy and other limited policies like that are important to have, and then appropriate training. But just a broad brush policy that says, you can't use social media if it affects the university or something like that. That's not going to fly.
Doug Bonney, Chief Counsel and Legal Director for the ACLU Foundation of Kansas. Thanks for joining us.
Thanks. Bye-bye.
You've been listening to On the Record Online with Eric Schwartzman, the podcast about how technology is changing the world of communications. To subscribe to the podcast or share feedback, visit us online at ontherecordpodcast.com, on Twitter at ontherecord, or send email to ontherecordpodcast@gmail.com.